Greetings, everybody. I am Syed Musab Rahim Hashmi, advocate, speaking from Narsingi, Telangana. With us, we have today Prashanth Bhai, advocate, and Sister Aisha, and Mohammed Amer Khan, law students. So please continue as it was planned in the sequence.
Good evening. My name is Aisha Qureshi, a law student at Sultan Ul Ulum College of Law. I'm currently doing a paid internship at the legal advisor law firm, which is headed by Advocate Azhar Mohammed Sir, who's enrolled in the Bar of Telangana and California, and managed by Advocate Syed Ilyas Sir, a senior Supreme Court advocate. I just want to take a moment to thank our mentors, Advocate Musab Rahim Hashmi sir, Advocate Azhar Mohammed sir, and Advocate Syed Ilyas sir. They have been very supportive, always guiding us and helping us understand the real world side of advocacy. Their encouragement and knowledge are shaping us into better future lawyers, and we're really lucky to have them. So I'm reading this article from the website Indian Express dated on October 7, 2024. Vice President Jagdeep Dhankar emphasized the importance of maintaining clear separation between the powers of the executive, judiciary, and legislature in a democracy. During a ceremony, he pointed out that executive governance, which includes decision making and implementing laws, should remain the responsibility of the executive branch. Similarly, legislatures make laws and courts give judgments. He expressed concern about instances where the judiciary might overstep its role and perform functions that belong to the executive. And according to him, this goes against democratic principles and the constitution. He also raised concerns about anti national narratives and stressed the need for intellectuals and the public to think critically and counter such ideas. His remarks underline the importance of each branch of government sticking to its constitutionally defined role for democracy to function properly. Thank you, sir.
Welcome, sister. So after the reading of the article, it's a open discussion. You can speak in Telugu, Hindi, Urdu, English as you like. We have with us the three law students. If you have any doubts about practical advocacy, please ask us. Today in the panel, we have two advocates, me and Prashant Bhai advocate. So we'll try to answer your questions.
There was one point which you were emphasizing, Aisha, that the court role should be stuck to making judgments. Is that right? If I'm not wrong. What Mr. Vice President said, is that right?
Sister Aisha.
Can you come again once?
Yeah, what you have emphasized in your argument is that the Vice President in a public attendance or a public meeting emphasized on the court's role should be limited to giving judgments. Is that right? Is that what you said?
Yes, sir. It was emphasizing between the powers of the executive, judiciary, and legislature that the
Okay.
powers should be separated.
Explain what he said about judiciary. What did he say? His statements in the true matter of his own words. What did he say about judiciary? What is the role of judiciary?
Yeah, one minute, sir. He emphasized the importance of maintaining clear separation between the powers of these three branches.
Correct. I'm only asking about what is the role of judiciary, which he explained. What did he explain? What did he say is the role of the judiciary?
Judiciary, he said that judiciary might overstep its role to perform functions that belong to the executive.
Okay. And what is the role that it should do, according to him?
According to him, this...
No, you said that
he said that this goes against democratic principles and the constitution.
Okay. No, once in our earlier recordings, you mentioned that the judiciary should be limited to giving judgments. Is that right or wrong?
Yes. Yeah. It
Okay.
should be
Okay.
limited to giving judgments. Yes.
Okay. Correct. Okay. Go ahead. Is there anything that you want to elaborate on, or your doubt is over?
No, sir.
Okay.
Thank you.
Okay. Anyone else who wants to talk and go further?
Yeah, so now we will take questions from the students. If you have any questions that what is practical advocacy, difference between study of law and practice of law.
No,
Today,
let us first discuss topic by topic, हाशिब,
yeah,
क्योंकि
yeah.
ये इनका आंसर एक जो है, क्योंकि फिर we cannot come back to the point again because we'll forget it.
Yeah.
What what do you think so? Shall we conclude this question first?
Yeah, we can give
We
like
can debate.
2-3 minutes for this, then we
Yeah.
can go the other topic.
Yes. And students, any further suggestions on this question that Aisha sister asked? Anyone can actually elaborate on this? Any ideas of yours which you can put forward?
Sister
Are
Shaheen,
they online?
you have come a little bit late, no? Sister Aisha can repeat her article reading, then you all will get more idea because few people have.
Okay.
Please,
Let
can you
me
repeat?
explain to Sister
Yeah, best
Shivans
ones, yeah.
with my little thought. See, basically, Aisha,
Yes, sir.
are you online? Yeah.
Yeah,
See,
yeah.
it is not judgments which the judicial system gives. The judicial system's judgments, actually, it is called judgment because the final verdict is there to be implemented or enforced. Otherwise, the role of the judicial role is to interpret the law. Interpretation is the only point of the judicial system. We are not here to make amendments or nothing, because amendments and everything should be made by the executive
Legislation. Yeah.
legislation. We are here just to interpret the law, nothing. But because the law has already been written, as you know, there is a constitution, and there are some judgments, a few judgments, whether the constitution, basic constitution, preamble of the constitution can be amended or not. You can refer to uh, one case argument, which
Yeah.
is SR Bommai
Okay.
versus the state of India. You can refer to that, where
Mm-hmm.
judgments are not made by a judge. Actually, it is pure interpretation of the law, where we call it a judgment. Interpretation of a law ultimately becomes a judgment. A judgment means pure interpretation of law. We, as the officers of law or whoever, do not have the requisite right to judge or give some ruling which is against or violating the basic preamble of the constitution. So all we can do is we can interpret the law. So there is no point of being high-handed. So all we can do is interpret the law.
Correct, sir.
Yeah. So that is how the understanding about a judgment is. A judgment is not a
Yeah.
judgment. It is an interpretation of the law.
Yes, yes.
Yeah. So that is how it goes. So this answers your point, or how does it go?
Got the point, sir. Got the point.
Okay.
Yes. Thank you.
All right. You can go ahead. Musa sir?
Yeah, so if anybody else has any questions about advocacy, they can go ahead ask. Today we have two advocates on the panel. Sister Shaheen, you have joined late now. Can you give your introduction? Mohammed Amer Khan, you have also joined late. If you are able to listen to my voice, if you could give your introduction.
आमिर ब्रदर, आप उर्दू में बोलिए, हिंदी में बोलिए, आप बेफिक्र रहिए, हम सब लैंग्वेजेस समझते हैं।
स्लो आपका एनर्जी लेवल बहुत हाई है आप भाई, थोड़ा स्लो।
नहीं, आप आराम से बात कीजिए, आप जो भी लैंग्वेज में बात करना है कीजिए। आप जो भी लैंग्वेज में, इंग्लिश में
Assalamualaikum,
बात
sir.
करना है, तेलुगु में बात करना है, उर्दू में बात करना है, किसी में भी बात कीजिए, समझते हैं हम। तो
Sister
आप
Shaheen, you were saying something?
Yes, sir. I am saying Assalamualaikum, sir.
Uh,
Hi, sir.
Hi,
हाय हाय।
you, sister.
So what you said, sir? Sorry, I could not able to hear. I'm engaged in some other work.
No
So
problem.
sorry, sir.
Brother Prashanth, advocate, could you summarize the discussion in short for?
So we have started today's session. Musab Saab advocate is a very learned advocate. He started the discussion today, and there are three students, law students. First student, she asked some question regarding an article which was published in Indian Express, where the vice president, in a public address, has quoted that the legal system is intervening into other systems of the constitution, like the executive or judiciary system is following steps or involving in other branches of the constitution, whereby they are limiting their powers to do favors to the public or factual favors to the public. So she required an answer where I would request the first sister, to answer what I have told her. Yeah, please respond.
Yeah, Sister
It's
Aisha,
better if
yeah, you can,
Yeah.
it is better if
yeah,
what my understanding of
because
law which I have
both are
interpreted to
speaking
you,
out
can
of
you explain to her?
you have just read the article, no? You can quote from the article as it is.
Yeah, so the vice president said that the court should give judgments. Okay, like the judges should give the judgments. But here Prashant sir explained that the judges will just interpret the law. We don't make the laws. The constitution, the preamble is everything all prepared. Here we just the judges just interprets the law and give judgments. Yes, this has been explained by Prashant sir.
Yeah.
Yeah, yes, sir. Got it, sir. Thank you. And one more thing I also want to add here, sir. While interpreting the law, the judges should also have to concentrate on the basic structure of constitution. The constitution must not they must not violate must not violate that.
Yeah, I have already put forth one case, SR Burma versus State of India. You can read that.
Yes, sir. It is one of the
So
famous case. Yes.
yes. So I've already quoted that. You were not there, so I missed out on that. So SR Burma, you can read that case. It's clearly stated that the constitution cannot be amended, or the preamble basically is the key to opening the constitution, cannot be amended. Correct.
Yes, sir. Yes.
So study one case of that, and
So,
other case is Raman Tirtha versus the State of
yes,
India,
sir.
and there are a few other cases where you can read that clearly the judgments have been ruled out and there's no further favor to that. SR
Yes,
Boma
sir.
is a nice case. It's easy to understand.
Yes, sir. It is. It is also one of the most important case, and
Yeah.
we can expect this question from the our coming AIBA exam also.
AIBA, yes, anytime these questions, see, fundamentally, these questions are basically asked everywhere.
Yes, sir. Yes.
Yeah. And anything else? Any doubts in practical part, or how? See, these are all theoretical questions which we are talking about. So, any practical aspects, if you can say anything has happened to someone around you, or where the aggrieved parties, if you want some natural justice to a party, we should discuss this as a case study so that we can understand more and how to relate it to theory in practical. Musab Saab, am I right or wrong?
Yeah, 100% right. So you are all studying law, and tomorrow you will be becoming good lawyers, God willing. So if you have any questions about how the court works and how an advocate is supposed to function, apart from the theoretical bookish aspects, if you have
Correct.
any questions about practical advocacy, this is the time to ask us. Sir was in a conference in another city. For us, he has taken out time. I was doing some work. I have taken out time. We both are giving, two advocates are giving you time. Whatever you want to know about practical advocacy, please ask. If it is in our knowledge, we'll give you. If it is beyond us, we may refer some other thing.
Correct. Correct.
Yeah, sir, I have one question. Like, can I go ahead?
Yeah,
Yeah,
yeah.
please. Please do.
So, is there any way to convert domestic violence case to attempt to murder case?
See, one thing, domestic violence. Domestic violence in what case? Is it for section 498 of the IPC or CRPC, or what are you talking about? Domestic violence could be anything.
Yeah.
Domestic violence in which section? Which section? 498?
498. 498.
Could be converted to attempt of murder.
Yeah.
It depends on the circumstances, evidences. See, because CRPC or IPC works on evidences and circumstances. It is not that we can convert it, because in CRPC or IPC, see, we are not basically understand as advocates, there are two kinds of services which we can render. One is prosecution, one is defense. Right? Most of the times we are defense lawyers. If you are in a private practice, most of the times in criminal cases, because prosecution comes from the government and the charge sheet will be filed by the government, by the police. So to convert civil, whatever, what you're talking can be done by the police, not by the advocates. Depending on the charge sheet and the inquiry of the police, what they have done and filing the charge sheet, if they book sections under 498 and attempt to murder is, see, something happens, the police is cooperating with the criminals, then we can enforce it through law. But we are defendants as such in all criminal cases. Advocates other than the government are defendants, defendant lawyers, not prosecutors. So I don't think there's any defendant lawyer who can directly convert something into domestic violence to an attempt to murder. But it has to be done through the honorable court to direct the prosecution to add few more cases where the charge sheet has been weak. That way we can enforce. But directly, basically what is there in the charge sheet will have to be followed. Right. Okay. That is how it goes. Did you understand?
So, some advocate will do like from private complaint, they try to make this as attempt to murder case through private complaint in the court.
See, through private complaint, no. See, what happens is, I'll tell you one thing. See, basically, all criminal charges are filed by the government. The government has to take notice of it, take a complaint, file an FIR, then take them to remand and book a charge sheet. Because what happens is, you have to understand two things. In criminal law, there are two things. One is the prosecution, one is the defendant. You cannot prosecute someone as a private lawyer. Understood?
Okay.
You have to be a government pleader to prosecute for us. Otherwise, you have to take a special petition from the court demanding that the prosecutor is not right, is in hand and right with the criminal. So we need a private lawyer to prosecute. There are chances that, very few chances, that the law will allow for a private prosecution. There are cases where instances have been there where private prosecution has been allowed. There is a rare chance, but it can be done. It can be done. There is a possibility. Yes. If there is a genuine reason, there is a possibility. It can be done. Domestic violence case can also attempt to murder section. Musab sahab, yaad nahi hai abhi to.
New BNS, yeah, most of the advocates, I also had to Google.
Because this
The new
BNS, PMS mein hai udhar.
yeah. It's 109, section 109 of BNS. Attempt to murder. 10 years.
अच्छा वो याद नहीं है सेक्शंस नया, उसमें पुराने में कंफ्यूजन है.
So
हो
like
सकता
sir,
है,
like
हो सकता है.
one of the advocate, like he told me like if that accused, so
Hmm.
if the other person of the family has attack on girl on some kind of like on what we say near chest, near body, then in that chances you can make that as attempt to murder case in
No,
that
no.
scenario.
What happens is it has to be written as a charge sheet by the investigation officer, IO.
Hmm.
वो
Hmm.
इन्वेस्टिगेशन ऑफिसर सेक्शंस जो भी ला अटेम्प्ट टू मर्डर विथ कल्पेबल होमिसाइड और अटेम्प्ट टू मर्डर नॉन कल्पेबल होमिसाइड, ये सब सेक्शंस अलग अलग है। वो
Hmm.
जिसके ऊपर रहता हो इन्वेस्टिगेशन ऑफिसर लिखना, अगर नहीं लिखा उन्हें कोलाइड हो गया वो क्रिमिनल के साथ, तो बाद में कोर्ट के थ्रू हम लोग इम्पीड कर सकते हैं उसको। आई मीन वी कैन पुट अदर सेक्शंस अगर एनफ प्रूफ
Okay.
है तो।
Okay, okay, got it, sir. Like now I got the clarity
So to
on
repeat
this.
brother Prashanth advocate's sentences in a different manner, एडवोकेट का काम नहीं है सेक्शन लगाना। जो आईओ है, इन्वेस्टिगेटिंग ऑफिसर है, उनका काम है वो।
Hmm.
आप एज एन एडवोकेट आपका ये काम है कि आप इधर उसको कंफर्म और डिनाई करो विद एविडेंसेस, या आप
Okay.
बोल सकते हैं कि भाई ये भी ऐड करिए या ये भी हटाइए बिकॉज ऑफ ABCD। तो
Hmm.
आईओ का काम है, आप एक पुलिस वाले हैं और आपको इन्वेस्टिगेटिंग ऑफिसर का पोस्ट दिया गया है, तो आप अपने हाथ से पेन से लिखते सेक्शन,
Hmm.
ऐसा है। और फिर चार्जशीट रहता,
Okay.
कई इश्यूज रहते, चार्जशीट हो गया, रिमांड रिपोर्ट हो गया, केस डायरी हो गया, FIR हो गया। आप डिफेंस लॉयर है तो ये पूरे पेपर्स में डिस्क्रिपेंसी कुछ है क्या बोल के देखते रहते ये टाइम पे। 80% एडवोकेट्स डिफेंस लॉयर्स ही बनते हैं, जो 10-20% है बहुत अच्छा पढ़े, वो एंट्रेंस एग्जामिनेशन पास करे, स्पीकिंग टेक्निक बहुत अच्छा है। सो इफ यू आर अबव द क्रीम, जब भी से आप पब्लिक प्रोसिक्यूटर, गवर्नमेंट प्लीडर, स्टैंडिंग काउंसिल बन रहे। सो मे बी 1% ऑफ माई स्टूडेंट्स में बिकम दैट ऑल्सो, आई एम नॉट श्योर, नोबडी कैन से। बट आमतौर पे वी आर प्रिपेयरिंग यू टिल द लेवल ऑफ डिफेंस लॉयर्स। Beyond that, आप
Okay.
थोड़ा yeah. So,
Yeah, thanks, sir, for your inputs.
welcome, welcome.
Yeah.
हाँ,
मुसाब साहब प्लेन लैंग्वेज में अच्छा सा समझा दिया आपको सबको।
थैंक यू, थैंक यू। सिस्टर शाहीन, आप कुछ बोल रहे थे तो वी हैड इंटरप्टेड यू, डू यू वांट टू कंटिन्यू?
Yes, sir. I already told that. But can I ask one question, sir?
Yeah, yeah.
Yeah, please go ahead. Please go ahead. If it
Yes,
is
sir.
within
So,
our knowledge, we will answer. Otherwise, we will inquire into it, study it, and get back to you. If it is beyond our knowledge, even after that, we will refer to someone else as well.
yes, sir. Okay, sir. Thank you, sir. Sir, my question is this. Nowadays, NDPS cases is increasing. So, as I'm practicing in Kukatpalli court, I saw some NDPS cases. So, my question is that if we get the bail in NDPS case, how much quantity should be there? And if we did not get the bail in NDPS case, what is the specific quantity of that?
See, quantity depends on so many factors. There are 290 substances which I've read. So different quantities are. See, you cannot defy anything in NDPS for a single valid chemical composition, because you have to read all the chemical compositions of the substance found. The substance chemical composition first has to be sent to forensic. Until then, any NDP substance which is in your blood level, you have to be arrested. Bail will only come depending on the substance, that basic grammage which is found. Third thing is, only after determination of the substance which has been found and its chemical composition, then the rules apply. You have to first, because see, I'll tell you something. In marijuana or something where even see 100 grams or 200 grams is not tradable. Whereas in high nitrous or something like ecstasy, or there are few very basic things and very advanced things where they cause lot of damage. So we have to analyze the chemical composition of the substance, only then these limits are fixed. It is not a fixed variable for anything into NDPS. So it depends on substance to substance.
Yeah, I will add to the answer and repeat the
Yeah,
same
please.
with a different
Yeah, please,
flavor.
please,
So
please.
about the bails, the books say, the books of advocacy and the law and the rules say that bail is the rule and jail is the exception. But practically in the courts, what is happening is a lot of times in the trial courts, lower courts, and in the high courts, the judges are not easily granting bail. So for bails also after trial court, then high court, then going to the Supreme Court, this is happening generally in practice. But the law book says that in general you have to grant the bail, and in exceptional cases when there are chances that the accused may tamper with the evidence, or he may influence or scare the witnesses, or he may leave the country without informing. Only in those scenarios they are supposed to not grant bail. But generally the trend has become that in NDPS they are not giving bails easily. This is
Correct.
one thing. And the second thing is the unwritten rule which they have made is that if it is a commercial quantity, then they are not easily giving bail. If it is a personal use quantity, they may give a bail easily. Then about commercial quantity, the classification of drugs, there are a lot of number of drugs, and for some drug, for example, this much quantity may be commercial quantity. For some drugs, this much quantity may be commercial quantity. So it depends on the potency and the which drug it is. That's the second thing. And the third thing is the 90-day period. Because the police people, the IO, they may take some time to investigate the cases because lot of caseload, workload may be there. So in the court, they may ask 4 days more remand, 10 days more remand, judicial custody, or like that. They can extend it for 90 days also. In the new BNS, BSS, they can go for up to 90 days without giving a bill saying that they are doing investigation. But some people have said that it's not an ideal scenario. And even after the BNS and BSS have come about, a lot of people are getting bails within 90 days also. It's not that everybody is staying in the prison for 90 days and then coming out on bail. So these three things are there. The bail is rule and jail is exception in the book. But in practical reality, things are a bit different than commercial quantity than 90 days. One of my personal advocacy experience related to NDPS when I was very new at the place of Syed Ilyas advocate, senior advocate. He had sent me for 10 kgs of, I think so, it was ganja or something, I don't recollect.
Marijuana, ganja.
So it was 10 kg marijuana. They seized it between Zahirabad and Sangareddy. It was coming from Orissa. So 4 people were there who were accused, and I had to argue the same matter in two courts. I don't know why it was at that time. It was my first experience of arguing the same matter in two courts. There was some overlapping of jurisdiction or something. I didn't get the reasoning for that. I first argued in the Sangareddy court. They granted the bail and they said I have to go to Zahirabad court and again argue there, saying that the bail was granted there. So maybe two police stations had done an FIR or something had happened. I couldn't figure out that aspect. But incidentally, at the both the courts for 10 kgs, in the first attempt of bail, it was granted, which is usually a bit less common. Maybe it was due to the name of Syed Ilyas sir, that he does only.
Not only him, but because of Musa Sab as well, because he prepares on the ground level very well and knows what to do.
Yeah, it's possible.
He's a humble person. He doesn't take credit for himself.
Oh, thank you, thank you. But then later, recently, I got a call about some 275 kgs, which was caught at Malkajgiri or somewhere. Balapur or Malkajgiri, I'm confused. But the client had come, the client's friends had come, had done some discussion. Then they wanted us to speak to the SHO and stuff, but then they didn't come around. I think they went to Legal Service Authority or some other advocate. No problem. But this quantity I had heard for the first time, 275 kgs. The scale of business is rising.
Yeah.
Prevention is better than cure. Yeah.
So this answers your question or some level of understanding, sister?
Yes, sir. Yes, sir. Yes, sir.
Some understanding might we would have thrown some light, if not complete answer for what you're seeking, but we should have thrown some light to your question.
Yes, I understand, sir. Thank you. Thank you so much, sir. It was clear and I understand, sir.
Anything else? Anything specific that you want to ask?
One question I have, sir, like as a fresher lawyer, so how we can improve drafting? How to accept expertise in drafting?
Expertise in drafting. Okay. Mm,
I will answer
that
it
is,
later
yeah,
on.
yeah, please.
Prashant bhai
Musa sab.
can answer.
No, Musa sab can better answer it. Yeah, he is a good drafter.
So it's like any other skill. It's like learning to drive, learning to swim, learning to cross the road. Once you have not begun, when you have never drafted anything, it feels like a big mountain. It's very difficult. You can't do. You get such feelings. When I didn't know how to draft, I also used to get अरे drafting में तो कुछ बहुत बड़ी चीज रहती. People come from the moon and the stars and do the drafting and go. I used to think like that, but then later on, when I started doing it, I came to know that it's simple, it's easy. Now, when I teach drafting, what I do is I have various stones. I teach drafting in this way. Now, I'll show you. I take one or two old files, then I have stones. This will be the first respondent, the government of Telangana. In our state, with all due respect, this is just symbolic to understand drafting. I have much respect for the government. Then this will be your second second respondent. If it
Okay.
is the matter related to registration, this could be the IGRS, Inspector General of
Revenue
Revenue.
stamps.
And then this will be the registrar office. Then you can have the sub-registrar. Then in the petitioners, I have round shapes. First petitioner, then incidentally, I got a stone with two rounds. This is second petitioner, and this is the third petitioner. So on the table, I put a scale, and this side are the petitioners, and this side are the respondents. To begin good drafting, you have to begin with the concept and the thing in your mind. You don't begin with pen and paper when you draft. You take stones or you take pens and pencils and you fix the petitioners, the respondents. You fix the quote. You fix what is your main prayer. What is your interim prayer? आपको चाहिए क्या है quote से? That's the prayer. फिलहाल आपको क्या चाहिए? Presently. That's the interim prayer. And then later on comes the format. Once you see any case file, you get to know the sequence in which things are there. I'll just take out one. You have the index page. After making the case file, it's better you attach yellow or pink papers, or you can take these white papers and stick them with a stapler or gun or gum, and you can easily open those papers in front of the judge. So because this is a writ petition, you have first service certificate. Service certificate is that which you take an acknowledgement from the standing counsels in the High Court before filing. You take the stamp, signature, phone number. Then you have the court fees. For one petitioner, it's 100 rupees. For one respondent is 30 rupees. Then you have the writ petition. In the writ petition page, you will have the court name followed by the case number, followed by petitioner and respondent 1, respondent 2, respondent 3. Then will be the address of office of the advocate with phone number and email address. Then you have the main prayer. And then that was the writ petition. Then you have annexure 1 and 2. In annexure 1 and 2, you write the sequence of events which the client tells you. He may describe to you in 3 hours. You will have to write them down in the form of paragraphs. Annexure 1 and 2. पहले ऐसा हुआ, फिर ऐसा हुआ, मेरे को दादा से जमीन मिली, फिर मैं उसको बेचा, फिर उन्होंने उसको बेचा.
तो लाइक स्टोरी सर.
हाँ, स्टोरी. हाँ, जो क्लाइंट आपको 3 घंटे स्टोरी.
So story we need to divide in different points.
हाँ,
Correct?
पैराग्राफ वाइज. वंस उन्हें स्टोरी बोलते बोलते लंबी सांस
Paragraph.
लंबी सांस लिया, नहीं तो तरवा था बोला, नहीं तो उसके बाद बोल के बोला, एंड देन बोल के बोला, पैराग्राफ चेंज कर दिया. क्योंकि फिर जजमेंट में भी बात
Okay.
पैराग्राफ्स कबूल होते हैं, वो पैराग्राफ्स रिपीट करो बोलते हैं स्टेनो को. एनेक्सर 1 एंड 2 में क्या हो गया, आपका स्टोरी हो गई. उसके बाद एफिडेविट एंड वेरिफिकेशन, मतलब क्लाइंट जो है
सर फैक्ट ऑफ द केस ना सर, स्टोरी होता क्या, फैक्ट ऑफ द केस होता सर?
फैक्ट ऑफ द केस में कैजुअली समझ में आ रहा
मुसाब साहब आपको जस्ट कैजुअली बोल रहे हैं इन अ लाइटर और वेन. आप ऐसा
अच्छा.
मत समझो. फैक्ट्स ऑफ द केस नहीं है, स्टोरी नहीं होता
नहीं होता फैक्ट्स ऑफ द केस. साइड
बहुत
इफेक्ट.
सीरियस ले ले रहे हैं आप.
नहीं, बट आपका क्वेश्चन करेक्ट है. हो, फैक्ट्स ऑफ द केस है एफिडेविट एंड वेरिफिकेशन. वेरिफिकेशन में उन्हें साइन कर रहा, मैं जो भी बोला, सच के अलावा कुछ नहीं बोला. उसके बाद हो गया अफिडेविट एंड वेरिफिकेशन. अफिडेविट एंड वेरिफिकेशन में भी सेम फैक्ट्स ऑफ द केस ब्रैकेट स्टोरी लिख रहे हैं आप.
मुसाब साहब मैं एक मिनट का ब्रेक ले रहा हूँ.
नो प्रॉब्लम.
अच्छा, एक मिनट.
कंटिन्यू. So affidavit and verification में the same story which the client told you, but आप उसको फर्स्ट पर्सन में लिखेंगे, आई बोल के, आई हम्बली सबमिट बोल के. उसके बाद हो गया P1 to P5 है. यहाँ पे P1 पूरे मटेरियल पेपर्स है, जैसे कि अपॉइंटमेंट लेटर हो गया, पट्टा, पाहनी, पासबुक, जमीन का अगर है तो सर्वे रिपोर्ट. ये पूरे P1, P2, P3 बोल के मटेरियल पेपर्स विथ डेट ऑफ डॉक्यूमेंट, डेट ऑफ फाइलिंग, पेज नंबर. उसके बाद क्या हो गया, वकालत मतलब वकालतनामा. उसमें दैट्स एन एग्रीमेंट बिटवीन द क्लाइंट एंड द एडवोकेट. उसके बाद क्या हो गया, रेस्पोंडेंट्स एड्रेस. क्योंकि नोटिसेस वगैरह कोर्ट से जाते हैं ना, तो ऑपोजिट पार्टी का क्या है एड्रेस, वो कैसा मालूम होना कोर्ट को. ये है ड्राफ्टिंग का इन शॉर्ट. एक टोटल ड्राफ्टिंग पे भी अपन एक रखेंगे सेशन, 1 घंटा डिस्कस करें तो थोड़ा आइडिया होता है ड्राफ्टिंग का डेप्थ में. और 1 मिनट है बस, वीडियो
सर
खत्म.
इस पे एक क्वेश्चन आता.
हाँ बोलिए.
हम चाहे तो स्टोरी जो है ना, चाहे तो हम
हाँ,
5-6 लाइन में खत्म कर सकते.
करेक्ट.
तो मैटर क्या है, थोड़े एडवोकेट जो है ना 12 या 13 पेज का बनाते. तो इसका रीजन क्या है कि जज को इम्प्रेस करना है या नहीं, हमारा शो करना है कि भाई हम वैलिड है, हम सच्चे हैं. तो इसका रीजन क्या है सर इतना बड़ा बनाने का?
बस टाइम पे फैक्ट्स डिस्क्राइब करने के लिए ज्यादा पेजेस भी लगते जेन्युइनली, बट बस टाइम पे
हम्म.
आप सच्चाई